Good evening and welcome. Tonight we engage with a profoundly challenging and deeply significant question for American society. Is the justice system in the United States fundamentally racist? This is a question that evokes strong opinions and touches upon the very core of equality and fairness in the nation. Joining us to dissect this complex issue are two distinguished experts. Dr. Samuel Jones, a renowned civil rights sociologist, argues that the system's structure and outcomes demonstrate fundamental racism. And Professor Evelyn Reed, a respected legal scholar and former prosecutor, who acknowledges disparities but contends the system itself is not fundamentally racist, emphasizing its complexities and ongoing reforms. Our format will begin with opening statements, followed by moderated discussions focusing on policing, sentencing, and systemic reform, concluding with closing statements. We aim for a rigorous, evidence-based, yet constructive dialogue. Dr. Jones, please begin with your opening statement.
Thank you, Isabel. The assertion that the U.S. justice system is fundamentally racist is not made lightly, nor is it based merely on isolated incidents. It is grounded in a comprehensive analysis of historical trajectory, empirical data, and the lived experiences of millions. We must first acknowledge the undeniable historical continuum. The system did not emerge in a vacuum. It evolved directly from eras defined by explicit racial hierarchy, slavery, and Jim Crow. Laws and enforcement practices were explicitly designed to control black populations. While the language of the law has become more race-neutral, the underlying structures and biases persist, adapting over time. Consider the war on drugs initiated in the latter half of the 20th century. Ostensibly about public safety, its enforcement disproportionately targeted minority communities, leading to unprecedented levels of incarceration, particularly for black men. The infamous disparity between crack and powder cocaine sentencing, for example, inflicted devastating consequences on black communities, despite similar pharmacological effects of the substances. This wasn't an accident, it was policy with predictable, racially disparate outcomes. The statistics paint a stark picture across the board. Black individuals are arrested for drug offenses at significantly higher rates than whites. Despite comparable rates of drug use, they face pre-trial detention more often, receive longer sentences for similar crimes, and constitute a vastly disproportionate percentage of the prison population. This isn't solely about overt prejudice from individuals, though that certainly exists. It's about systemic racism, the ways in which institutions and systems create disparate outcomes, even in the absence of explicit discriminatory intent. Implicit bias deeply permeates the system. Unconscious stereotypes can influence police officers' decisions on whom to stop, search, or arrest, prosecutors' decisions on charging and plea bargaining, and judges' decisions on sentencing and bail. Furthermore, the very structure of certain laws and procedures, like cash bail systems that penalize poverty, which is correlated with race due to historical disadvantage, or broad prosecutorial discretion, facilitates these biased outcomes. The cumulative effect is a system that systematically disadvantages racial minorities, functioning as an engine of racial inequality. Therefore, the conclusion is inescapable. The system, in its fundamental operation and impact, is indeed racist.
Professor Reed, your opening statement, please.
Thank you, Isabel. Dr. Jones raises critical points about historical context and present-day disparities, which are undeniably serious and demand our sustained attention and action. However, I must respectfully disagree with the characterization of the U.S. justice system as fundamentally racist. To label the entire system as fundamentally racist is, I believe, an oversimplification that overlooks its core principles and the complex web of factors contributing to the disparities we observe. It risks eroding trust in the very institutions, however imperfect, that are designed to uphold the rule of law. The American justice system, at its foundation, aspires to neutrality and equality. Principles like the presumption of innocence, the right to counsel, the right to a jury trial, due process, and equal protection under the law are its cornerstones. These are not inherently racist ideals. Quite the contrary, they are intended to safeguard individuals against arbitrary state power. The existence of disparities, while deeply troubling, does not automatically equate to the system's fundamental nature being racist. Correlation, even stark correlation, does not solely prove causation resides within the system's design itself. We must consider the influence of complex, external socioeconomic factors that intersect with the justice system. Disparities in outcomes often reflect broader societal inequalities. Disparities in poverty, education, housing, healthcare access, and exposure to violence, which disproportionately affect minority communities and can correlate with higher rates of certain types of crime reported to police. Furthermore, while acknowledging the historical legacy Dr. Jones mentioned, we must also recognize the significant progress and ongoing reform efforts aimed at mitigating bias and addressing inequities. We have seen bipartisan sentencing reforms like the First Step Act, increased focus on implicit bias training for police and legal professionals, the proliferation of drug courts and diversion programs, and enhanced data collection to better understand and track disparities. These efforts demonstrate a capacity and willingness within the system to self-correct and address its failings, which contradicts the notion of it being inherently fixed in a racist framework. Attributing all disparities solely to systemic racism overlooks the agency and choices of individuals, as well as the genuine efforts towards fairness by countless actors within the system. Therefore, while I fully concede the urgent need to combat racial bias and reduce disparities wherever they exist, I maintain that the system's foundational principles are not racist. The challenge lies in ensuring those principles are applied consistently and equitably, addressing both internal biases and external societal factors, rather than condemning the entire structure as fundamentally flawed by design.
Thank you both for those comprehensive opening statements. Let's now delve into specific areas, beginning with policing and arrests. Dr. Jones, concerns about racial profiling, tactics like stop and frisk, and documented disparities in traffic stops and use of force are persistent. How do these phenomena support your argument?
These are not mere anomalies, Isabel. They are patterns indicative of systemic issues. Data consistently shows that Black and Latino individuals are stopped, searched, and subjected to force by police at significantly higher rates than their white counterparts, often with lower contraband hit rates, suggesting the stops are less justified by suspicion of actual wrongdoing. Practices like stop and frisk, even when legally sanctioned under certain conditions, have been shown to be overwhelmingly targeted at minority communities, fostering immense distrust and antagonism between police and the residents they are sworn to protect. This isn't just about individual bad apple officers. It reflects departmental priorities, training, or lack thereof, and often, deeply ingrained implicit biases that associate race with criminality. These practices effectively criminalize entire communities based on race and location, acting as a gateway into the justice system for minor infractions, or based on mere suspicion.
Professor Reed, how do you respond? Are these policing patterns evidence of fundamental racism, or are there other primary drivers?
While the disparities Dr. Jones highlights are concerning and require rigorous investigation and oversight, attributing them solely and directly to systemic racism within policing is problematic. Policing strategies, including proactive stops or saturation patrols, are often deployed in response to reported crime rates and patterns, or even community requests for increased police presence in high-crime areas. It's a complex equation where deployment decisions based on crime data can inadvertently lead to more interactions with residents in certain neighborhoods, which are often predominantly minority communities due to those broader socioeconomic factors we discussed. This doesn't excuse racial profiling or excessive force, which must be condemned and addressed through robust accountability mechanisms, better training emphasizing de-escalation and procedural justice, and community policing initiatives. However, we must differentiate between addressing misconduct and bias within policing versus declaring the entire function of policing as fundamentally racist. The latter risks undermining the necessary work police do in maintaining public safety, often under dangerous and difficult circumstances.
But Professor, if policing strategies consistently produce racially disparate results, even if ostensibly based on neutral factors like crime data, doesn't that point to a systemic issue? The outcome is discriminatory, regardless of intent.
The disparate outcome requires scrutiny and remedy, Dr. Jones, absolutely. My point is that the remedy might lie in refining the strategies, improving data analysis to avoid proxies for race, enhancing accountability, and crucially, addressing the root causes of crime concentration, rather than concluding the system's fundamental design is racist. Focusing solely on police tactics without considering the societal context provides an incomplete picture. We need multifaceted solutions, including investing in those communities to reduce the conditions that correlate with crime.
Let's transition to sentencing and incarceration. We see enormous racial gaps here. Dr. Jones, factors like mandatory minimums, prosecutorial discretion, and plea bargaining are often cited. How do these contribute to the racial disparities?
These mechanisms are critical drivers of disparity. Mandatory minimum sentences, often enacted during the height of the war on drugs, removed judicial discretion, leading to excessively long sentences, particularly for drug offenses where racial disparities in arrests were already prevalent. While ostensibly race-neutral, their application had a demonstrably harsher impact on minority defendants. Prosecutors hold immense power, deciding whom to charge, what charges to bring, and what plea offers to make. Studies suggest implicit bias can influence these decisions, leading to harsher charges or less favorable plea deals for minority defendants compared to white defendants facing similar circumstances. The sheer volume of cases means most are resolved through plea bargains, where the threat of severe mandatory minimums can coerce defendants, disproportionately minorities, into pleading guilty, even if they might have a defensible case. This creates a cumulative disadvantage. Disparate arrests lead to disparate charges, which, under threat of disparate sentencing possibilities, lead to disparate rates of conviction and incarceration. It's a pipeline where racial bias, implicit or explicit, can compound at multiple stages.
Professor Reed, your perspective, how do you reconcile these disparities with the notion of a system not fundamentally based on race?
The issues of mandatory minimums and prosecutorial discretion are indeed areas where potential for disparity exists, and reform has been rightly focused. The legislative intent behind many mandatory minimums, for instance, was often to target high-level traffickers or address specific crime waves, though the outcomes were sometimes broader and more severe than anticipated. It's important to note that sentencing is also heavily influenced by factors like criminal history and offense severity, which are legally relevant considerations. Disparities in sentencing may, in part, reflect disparities in these underlying factors, which, again, can be linked back to broader societal issues rather than purely systemic racism within the sentencing laws themselves. Regarding prosecutorial discretion, while the potential for bias is real and must be guarded against through training, guidelines, and data transparency, this discretion is also seen as necessary for individualized justice, allowing prosecutors to consider mitigating circumstances or divert low-level offenders. Furthermore, significant reforms have occurred. The First Step Act reduced certain federal mandatory minimums and made retroactive changes to address disparities like the crack powder cocaine gap. Many states have also pursued sentencing reform and expanded alternatives to incarceration. These reforms show the system is adaptable and not inherently fixed on racist outcomes. Addressing remaining disparities requires continued refinement of laws and practices, ensuring checks on discretion and robust appellate review, not a wholesale condemnation of the system's foundations.
But, Professor, the scale of incarceration disparity is staggering. Black men are incarcerated at roughly 5 times the rate of white men. Can incremental reforms truly address something so vast? Or does it suggest a deeper, more fundamental problem?
The scale is indeed alarming, Dr. Jones, and demands urgent, comprehensive action. However, attributing this solely to the justice system's fundamental nature ignores the complex interplay with societal factors and the history that led to concentrated disadvantage. Incremental, evidence-based reforms, when sustained and widespread, can accumulate into significant change. Focusing on specific mechanisms like bail reform, sentencing guidelines, reentry programs, and addressing implicit bias, while simultaneously investing in communities to tackle root causes, is, in my view, the most constructive path forward.
This brings us to the question of systemic issues and reform. Professor Reed, if not fundamental racism, how do you explain the persistence and breadth of these disparities across so many stages of the system?
I attribute the persistence primarily to two intertwined factors. First, the enduring legacy of historical discrimination, which has created deep-seated societal inequalities in areas like wealth, housing, education, and health, all of which correlate with justice system involvement. Second, while the system's core principles aim for neutrality, the practical application by human actors within that system can be flawed, influenced by implicit biases, resource limitations, or policies with unintended disparate consequences. These are serious failings that need addressing, but they are failings in the asterisk application of the system, not necessarily evidence that the foundation itself is racist. Therefore, the most crucial areas for reform involve improving the equitable application of the law, enhancing data collection for transparency, rigorous implicit bias training, refining sentencing guidelines to reduce unwarranted disparity, promoting alternatives to incarceration like treatment courts, strengthening indigent defense, and ensuring robust oversight and accountability mechanisms. Radical overhaul risks dismantling structures that, while imperfect, provide essential frameworks for due process and the rule of law. Targeted, evidence-based reform within the existing structure is the pragmatic approach.
Dr. Jones, is incremental reform sufficient, or is something more fundamental required?
With respect, Professor Reed's distinction between flawed application and fundamental nature becomes semantic when the flawed application is so pervasive, persistent across time and geography, and consistently disadvantages the same racial groups. When the outcomes are reliably discriminatory at scale, the system itself must be considered fundamentally flawed in its relation to race. The sheer breadth, from policing to bail, plea deals, sentencing, and even conditions of confinement and parole, points to something deeper than just scattered biases or flawed applications. It points to a structure where bias is embedded, implicitly and sometimes explicitly. Incremental reforms, while welcome, often tinker at the edges without addressing the core power imbalances and historical legacies. They haven't reversed mass incarceration or eliminated the profound racial disparities. Therefore, more fundamental structural changes are necessary. This includes significant bail reform, potentially ending cash bail entirely. It involves decriminalizing low-level drug offenses and shifting towards public health approaches. It requires robust, independent civilian oversight of police departments with real power. It means fundamentally rethinking prosecutorial power and incentives. Crucially, it demands massive reinvestment in marginalized communities to address the root causes: poverty, lack of opportunity, inadequate education and healthcare, that the justice system is often used to merely contain rather than solve.
We have reached the point for closing statements. Dr. Jones, please summarize your position.
Throughout this discussion, we've traced the undeniable lineage from slavery and Jim Crow to the present-day realities of the U.S. justice system. The empirical evidence is overwhelming. At virtually every stage, from initial police contact through sentencing and incarceration, racial minorities, particularly Black Americans, face demonstrably harsher outcomes. These are not isolated incidents, but consistent patterns fueled by historical precedent, implicit bias woven into decision-making processes, and laws and policies that, regardless of stated intent, produce racially disparate impacts. Concepts like the war on drugs, disparate policing tactics, cash bail, prosecutorial discretion, and sentencing disparities all contribute to this reality. To argue this is merely flawed application ignores the sheer scale, persistence, and predictability of the racial inequality generated by the system. A system whose operation so reliably produces discriminatory outcomes based on race, perpetuating racial hierarchy, must be understood as fundamentally racist in its impact and function. Acknowledging this fundamental nature is not about assigning blame to every individual within the system, but about recognizing the systemic reality. It is the essential first step towards envisioning and implementing the kind of transformative, structural reforms necessary to achieve genuine justice and equality for all Americans. The human cost of inaction, measured in lives disrupted and communities devastated, demands nothing less.
Thank you, Dr. Jones. Professor Reed, your closing statement.
Thank you. We have engaged in a critical discussion about profound challenges within our justice system. I reiterate my deep concern regarding the racial disparities Dr. Jones has highlighted. These demand serious, ongoing attention and remedy. However, I maintain that labeling the entire system fundamentally racist is inaccurate and ultimately counterproductive. The system's foundational principles, due process, equal protection, presumption of innocence, are aspirational pillars of fairness, not inherently racist doctrines. The disparities we observe are often the product of complex interactions between the justice system and deeply entrenched societal inequalities, combined with instances of bias and flawed policies within the system that require correction. We must acknowledge the role of socioeconomic factors, differential crime rates reported to authorities, and individual accountability alongside systemic issues. Crucially, we must also recognize the significant, ongoing efforts towards reform, changes to sentencing laws, enhanced training, the development of diversion programs, and increased data transparency. These demonstrate a capacity for improvement and adaptation, not a system irredeemably rooted in racism. Characterizing the system as fundamentally racist risks undermining public trust in the rule of law itself and alienating potential allies in the essential work of pragmatic, evidence-based reform. Our focus should be on rigorously identifying specific sources of bias and disparity, implementing targeted solutions, improving accountability, and addressing the broader societal factors that contribute to these problems. Let us work constructively to ensure the system lives up to its foundational ideals of fairness and justice for every individual, rather than resorting to rhetoric that could inadvertently weaken the very framework we seek to improve.
Dr. Jones, Professor Reed, thank you both for sharing your expertise and engaging in this vital, albeit challenging, conversation with such rigor and conviction. Tonight we've explored the deep tension between viewing the justice system's racial disparities as evidence of fundamental racism versus seeing them as complex issues within a framework striving for neutrality. We encourage our audience to continue reflecting on the powerful arguments and evidence presented. Thank